My lord,
Yes.
I beg to mention item number 18, my lord.
Item number.
Petitioners in this case want to withdraw this petition, my lord.
Okay. Mr. Khatania, learned counsel for the petitioner submits that the petitioner he has instruction to withdraw the present petition. In view of the aforesaid, the present in view of the aforesaid, this criminal petition stands closed on withdrawal. Interim order, if any, stands vacated.
Obliged.
That's it. Lord, I'd like to mention item number 15, my lord.
15.
15.
Yes.
My lord, in this matter, Learned Counsel TC Sutia has been engaged, my lord, by my client. And he has been suffering from a head injury, my lord.
Sir Sutia,
Yes, my lord.
what happened to him?
On the Diwali day, he fell down from the bed, my lord.
It is submitted
I need some.
MSS Borpatra Gohai. Learned Counsel submits that Mr. T.C. Sutia, Learned Arguing Counsel, had met with an accident and therefore he could not remain present in this court to court. Accordingly, prayer for adjournment is made on his behalf. Prayer stands allowed.
At least
this matter
2 weeks, my lord.
after 2 weeks on a
Because
date
he is
to be
under
fixed by
medical
registry.
observation, my lord.
Yes.
Obliged,
May it please your lordship. I beg to mention item number
17.
consent of the other side.
Hmm.
Counsel A.M. Bora is not keeping.
Who is for the respondent? Anybody? Okay.
Consent lordship.
Okay. On Tuesday. Same. Or Mr. Bora is not keeping. Tuesday or what is
Monday, lordship.
Monday? Okay.
Much obliged.
May it please your lordship.
Hmm.
But I beg to mention item number 12, lordship.
20?
Lordship 12. Item
1, 2. Yes.
Lordship, this matter became infructuous.
Mr. Sharma, R. Sharma, Learned Counsel for the petitioner submits that this matter has become infructuous. Accordingly, criminal revision petition stands closed, being infructuous. Interim order, if any, stands vacated.
Thank you.
May it please your lordship. I beg to mention for withdrawal of a criminal petition, as the petitioner, he wants to be tried in the lower court. We do not want to proceed further with the
Which case?
criminal petition, not unlisted matter, but it was in the criminal petition
Pertaining to which year?
this year, 2024.
Hmm?
2024. This year only. LCR was called for.
No, then you will have to make this mention before the criminal bench, regular criminal bench. Because this matter, this court is taking matters up to 2019.
Oh, yeah. Oh.
Yes. So beyond 2019.
Yes. Okay.
May I please English. This is Sarsited matter, lordship.
Hmm.
My lord, item number 2, I was earlier asked to get the instruction. After some time, my lord, I will get the instruction.
Supplementary is there?
3, my lord, case diary not received, my lord, earlier rejected by your lordship.
Okay. When?
Any short date, my lord, on 27th, my
27 CD notice. Yes, after something along with that matter will take up.
yes.
My lord, in the last, as per order, my lord, lordship may kindly please 15/5 last order, my lord. As per the information expired, my lord.
Now,
Not receive any receipt.
office note reflects that the
1411, my lord, office number.
1411.
My lord.
So you obtained this from the Dolgaon police station.
My lord.
That's all.
I have also tried minor simultaneously from the advocate also.
The
So old matter.
Learned additional public prosecutor submits that he may be granted some time to complete the instruction in terms of this court's order dated 15/5/2024, in as much as office note dated 14/11/2004 reflects that the officer in search Dolgaon PS station Dorong has not submitted any report in terms of this court's earlier order dated 3/8/2023. Full stop. Prayer is allowed. List this matter on.
They have to take instruction next week, my lord. And
Give a date. You intimate the IO.
My
This
lord.
is the situation.
My
If
lord.
necessary, download the order, send it, and let him have the instruction.
My lord.
Unnecessary. This is
my
pending
lord,
from
my lord.
2009.
9 months.
So, or later date be fixed, my lord, third
Help us
December.
cleaning all these matters.
3rd December to fix করে লোক মই পাবো পাৰো খবৰ
Third.
3rd December, my lord.
3rd of December. Yes, next case.
আমি চাব চেষ্টা কৰিম।
মই খবৰ পাব পাৰো।
Yes.
May it please your lordship. Lordship, this is a suo motu petition taken up by the High Court. Registry was directed to take steps in item number 5, lordship.
What is the office note says?
No ID card received back.
Steps upon notice upon which
In item number 5, lordship, respond number 2.
who is respondent number 2, the accused, who was discharged?
He was not discharged.
The accused was discharged.
No, yes, lordship, he was discharged.
Huh?
Hero Dole.
Respondent number 2,
Yes, lordship.
Mr. Pathak appeared earlier.
Lordship, he was there for a long time. After that, they said that he would not be appearing.
Where is that?
Lordship, there is an order to that effect. 3/1/2023, lordship.
T1.
2023.
There is no order of 3/1/2023.
Lordship, maybe it is in item number 6, lordship.
No, item number 6 is different.
It's a similar matter. The argument in item number 6 was already over. However, because of item number 5, it could not be done.
Respondent number 2.
Yes, lordship.
Who is respondent number 2? That is,
Mr. Khirod Dole.
Huh?
Mr. Khirod Dole.
what is his address?
That I am not aware of.
And what about the other case? Both notice upon respondent number 2.
No, lordship, only in one case.
Huh?
Only in one case. In item number 5,
And what about item number 6?
she is representing.
Represented by whom? Huh? Respondent number 2. Same person.
No, lordship, it's a different person. In item number 6, it's a different person and she is on behalf of J5.
Write down in item number 2. Item number 5. This matter was taken suo motu. Suo motu. However, the suo motu in the year 2009. However, service upon no, full stop. Subsequently, the respondent number 2, though entered appearance through a learned counsel, through Mr. Bivas Pathak, learned counsel. However, subsequently, the said counsel withdrew from the brief. In view of the aforesaid, this court directed issuance of press notice upon the respondent number 2. Full stop. However, till date, service is not yet complete. Accordingly, registry is directed to do the needful for service of notice upon respondent number 2 through the jurisdictional police station and through the office of the learned public prosecutor Assam. First of such steps be taken within a period of 10 days from today, and thereafter list this matter after 4 weeks on a date to be fixed by registry. 4 weeks and thereafter list this matter on, give a date after 4 weeks or immediately before vacation. 20 December 2024. First of registry shall update office note in this regard. First of. Okay. Now, what about the other method? Why should we take it up together?
Lordship, it's a similar matter and
Oh, not similar matter.
the,
Two persons were acquitted
by the
isn't
same
it?
judge.
by the same judge.
Lordship, this
There was a recommendation of departmental action against the judge. He was compulsorily retired. And there are two things. So why should we wait in item number 6?
Lordship, hearing was already
We are,
had already completed in item number 6. Lordship may kindly find that order in 3/1/2023, wherein it is recorded.
item number 6.
Yes, Lordship.
When? 21?
3/1/2023, there is an order wherein I have submitted that the argument submitted in criminal revision petition number 3.
Oh, that is gone. No judgment is reserved. No part heard. 1 year. It can be at best 3 months.
Lordship may kindly take up the matter together.
No, we'll not take up together.
May kindly,
No, why? See, we are not taking any legal action against the officer. Officer has been already compulsorily retired. There were two parts in the when suo motu was taken. One is for revision of the order of acquittal suo motu, and other part is departmental action. That has already been done. Why should we? We are not doing anything in this case against him otherwise. So, and two different, one is under Excise Act, Excise and Forest Act, and other is under something different. So, yes,
Lordship, I'd like to pray that Lordship may kindly give me another date,
now
Lordship.
we'll give you another date. That is not a problem.
Lordship, otherwise this, the
Mr.
person,
Talukdar, you also appear for somebody in this case.
It is not there with me. There most of the services. In item number 7.
But you are appearing,
I am appearing.
then why service is not complete? Service is
No,
complete.
so far most of the respondent number 2, nobody is there. I am appearing for respondent number.
Okay. This is, it is not your case. Item number
Yes.
7 is different.
7.
7 is,
7 is.
yes, I got a little bit
Silence.
confused. And, okay, then when? Okay.
any date, Lordship.
Okay, we are fixing it on that, what is the date? 28th of December.
Sure.
But no further adjournment
Sure.
in your case. Okay,
Much
list along with so and so on so and so. Okay. This is, what is this? This is, I don't know. This is it. What is this? This is 6. And this is no.
I think 7.
Yes, what is this?
Here most of the service is not complete.
Service upon whom?
Most of the respondent number 2.
Who is respondent number 2?
7 burglary. And that magistrate most probably, whether it is served or not, that I do not know. SK Surya and SSA Rahman, judicial magistrate.
They have also been, I think, voluntarily retired, something like that.
But nobody has entered appearance on behalf of them.
I respondent number?
I am appearing in respondent number 34679.
Okay. And who
And
is
he is
for
for
1?
I am for Poniram Bosumotari and Ruhiram Khaklari.
1 and 10.
And 1 and 10.
1 and 10. And who remains then 2?
2 remains, 2 and 8
10
remains.
accused number 10, my lord. Respondent number, I don't
No,
have
no,
the.
who remains?
Oh.
2 and 8 remains.
2 and 8 remains. Okay.
তুমি ইয়াতে পাইছা না ইয়াতে 9 10 নাই কোনো
Oh, no.
Respondent number 1 is represented by
UK bound.
UK.
he is
Okay. You are for respondent number 1.
Yes.
1
There is
1 and
that-
10.
1 and 10, my lord.
10.
10 is Rohiram Khaklari, my lord.
No, it is not shown in the cause list, but he is appearing for 1 and 10.
It is seen that notice in respect of respondent number 2 and
8.
2 and 8 is not yet completed. Huh? Same order. Like earlier, registry will take steps through so and so, so and so. And list this matter on that same date,
20.
28th of this.
Please, your lordship.
Yes.
The last occasion, your lordship was pleased to appoint me as an amicus on the
Uh-huh.
matter.
So have you gone through it?
As I've gone through the records, my lord. Only issue is that the evidence which has been given, some of it is in Bengali. I can get that. I've got that translated. But when the registry has photocopied, I think it was photocopied from legal. So some portions are missing. I will get that check from the record,
Okay.
my lord.
So let us fix it for hearing.
Hearing, my lord.
Huh?
In the meantime, I will.
Okay.
Otherwise, my lord.
Pursuant to this court's order dated 4/11/2024, Mr. Nawaz, learned counsel is present. Mr. Nawaz, amicus is present. Full stop. This matter is ready as regards service and record. Accordingly, list this matter for hearing on. How much time will you take?
Not much. I've gone through everything, my lord.
Nothing.
Judgment is otherwise.
When? No, not possible in November. 2012 matter. Give preference. First 11, 12, 13, that's where I will go. 26th of November for hearing. Yes. Yes, Mr. Bhattacharya.
The record has come.
Hmm.
I'll have to concede the matter, my lord. Because already fine have been imposed, enhanced from 3,000 to 5,000. And
Yes, please.
has been paid. She has received it also. So it is a love affairs, my lord. So facts of the case is, my lord, they are in love in 4 years. So she conceived a baby. She, that is the petitioner's claim.
We'll
is there.
close it. Close it. You have paid it and will not
I'm no wish.
Spencer Learned Counsel submits that this present application is filed under just a minute, huh? There is no stay also.
There's a stay also,
Okay.
subject to the payment of 5,000.
Uh.
Lately, the court has given the fine also.
Punishment was for
6 months
6
and
months.
3,000.
3 months and 6,000.
6 months and 3,000.
Huh?
6 months and 3,000.
6 months under
Under 417.
6 months under 417.
17. And with fine of rupees 3,000. In
Fine of-
default,
Rupees
3,000. In default, SI for 20 days.
SI for 20 days. What was the ground?
Mount Pilot failed to marry. And she has was in love with the boy for 4 years. Then there was a
Where is the initial deception part? How it was dealt?
Milot PW1 Milot. Yes.
PW1
PW1 Milot.
What was her statement?
statement that she was in love with her.
But
And,
he is the promise to marry her.
Marry.
On the context, Milot, he has committed the physical relation with her, Milot.
It's a
Thereafter she,
consenting party, my lord. For 4 years they were there. So-
Initially, that is not in her statement. She's categorically stated that he has come to his home and thereafter on the pretext of on the on the on the pretext of my lord Mary, her, he has committed the offense, my lord. Thereafter, he refused to marry her. PW1, my lord.
PW1, give the LCR.
My lord.
This is item number 9.
9, my lord. I have
What is the LCR of other case? There is an order.
far as death record not received.
Why this in view of records of criminal appeal number 21? That is the criminal appeal.
Appeal, ma'am.
What will do with appeals record? Evidence is not there. Evidence is there.
Yeah.
That's all. Our evidence is unshaken
In the cross part also.
in cross part also. So that remains. How will you revert it?
What I say, my lord, I'm not contesting that map. There was some love affairs, there's some mistake has been done by this. Now she got married to the another man, this man also got married to the another. Now the question is, my lord, I'm not asking for acquittal, my lord. I say that let the compensation, because it is 417 with fine.
What is the punishment under 417?
My lord.
6 months, one.
Here, my lord.
No. What should be as prescription?
My lord, whoever cheats shall be punished with imprisonment or either description for a term which may extend to 3 years,
And
or with fine, or with both.
So 6 months.
or with fine or with both.
6 months already, my lord, given by the court.
Hmm.
So I say that monetary compensation is already court has given from 3,000 to 5,000.
Ah.
Clear that it may be also
Now you were in custody for some period.
some period we are there.
What is that?
Custody.
This actual.
So suppose if we convert the period undergone, so it may extend or fine. Fine he has already paid. Fine he's already paid. So in that matter we can close it.
My lord.
Kindly see the record and how many days you are there. We'll take it up tomorrow.
My lord.
Tomorrow. Okay.
But in fact, my lord, I don't have any record with me.
No, just you go through it.
How many days he is in the con?
He is in. Accordingly fine and we'll con.
And himself, herself admitted that he was in love with 4 years.
No, that's true, but she has consistent that he promised and that's why. And there is no suggestion, nothing of that sort. Just go through it.
Fine.
Release this matter tomorrow.
Tomorrow. Tomorrow, my lord, tomorrow I may be out.
No, we'll record it then. Ask your junior to
Yeah,
be here.
my lord.
It pleases your lordship.
Yes.
Lordship, as per ordered, office note dated 3/1/22, notice was issued upon respondent two. But by registered post with AD on 18/12/21. But neither AD card nor unserved notice has been received back in the section.
Where is that?
On order dated 3/11/2022.
3/11?
3/1/2022.
22.
Yes, sir. 3rd January.
What is the punishment?
It is also under section 417,
417.
1 year conviction. One year,
What is the period?
1 year, my lord.
Who is the accused? Name of the accused?
Gulak Kathar.
Golok
Gulok
Kathar.
Kathar. Yes, what is wrong in this order? If we appeal the acquittal, you need not serve a notice upon the victim. Yes, tell us. What is wrong? Where is your senior?
Good, Your Lordship.
Call him. Yes. Yes.
Report is already received, is around 498 for 1 year. He give a short.
What received?
LCR received.
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 Received. We are hearing it, this matter. Why? How much time you need? This is pending since 2013. Who is your senior? On the ground of senior, no adjournment.
And my lord, the basis of the evidence of village. The children is also there in the house. They were not examined. The brother of the victim.
What the lady says? What the lady says?
My lord, victim
Victim.
said that he is tortured physically, my lord, and earlier he is also tortured on intoxicated by demanding.
When can you do this matter? Tomorrow? We give a date. This matter is ready for hearing accordingly. List this matter. It was admitted.
Lordship.
List this matter for hearing on. You can give it in December also. 4th of December. No adjournment on that day. LCR is there?
LCR.
None appears for the petitioner on call. This matter is ready as regards service and record. Accordingly, list this matter for hearing on a date to be fixed by registry. 2014, registry will
Fine.
fix it. 11, 12 will.
Mine.
Yes.
My lord, service of the notice could start with the resident number. Comment, my lord.
What is the issue here?
Flag mark. Issue, my lord. Flag mark, I have flagged the order. It is also try to start the notice to the consent CGM, my lord. I have given the flag mark, my lord.
What is the issue here?
It's, my lord, that is the petitioner is working under the private firm, my lord. An allegation is that he has not deposited the money to his bank account.
It was a CR case or GR case?
It is GR case, my lord.
So not necessary respondent. In view of the extent norms, respondent number 2
LCR also received.
is not a necessary party. However, the respondent number 2 shall have a right to participate in this proceeding. In view of the aforesaid, the matter is ready as regards service and record accordingly. List this matter for already admitted.
Admitted, my lord. Already admitted.
When which order? I do not think it is admitted. When I admitted, accordingly list this matter in the admission column. On, give a date. Not January, what you say? Admission, we'll finish it up with admission.
Admission.
11th of December.
Already, my lord.
Yes, what is the present status?
We are about to apprise this court regarding the bank account, Your Lordship.
Huh?
Regarding the bank account.
You have
yes,
apprised the bank account.
I have already submitted a detail.
Yes, what is the present status?
Lordship,
RTGS they have given.
yes, Lordship, but Lordship, may kindly, I want to take Lordship's attention to read petition, that affidavit where the
No, issue
petition-
is let us not go to all this. Right now, issue was initially they alleged that you wanted a receipt to be signed, therefore she refused.
Lordship.
This was case. Then she was not appearing. Then we
Yes.
call them. You took a stand that no, we cannot give money like that. We'll only transfer through RTGS.
Yes,
But they are not coming forward to give us the details. Now they have given you the details.
Lordship, the signature, Lordship.
Huh?
Lordship, in additional affidavit, Lordship may see the signature of the petitioner is in English, Lordship, whereas in the writ petition, he has signed it in Hindi, Lordship. Lordship may kindly consider that.
Where is that?
Petition.
No, do you
affidavit-
say that this is not his bank account?
Bank account, we don't have any issue with the bank account, but.
Just transfer it to the bank account.
Lordship,
Matter is there.
Lordship, Lordship, they have given, we will transfer it.
You
But-
transfer it to the bank account. That's all.
Lordship,
That's all.
Lordship.
We are not, because bank account now it's up to him whether he gives to the lawyer or to some other person. It's not our business.
Lordship, Lordship,
It is not, it should not be your business also.
Lordship,
So you transfer it to the bank account.
Lordship.
Learned counsel for the, so if you doubt, you can lodge FIR, you can file complaint, then we'll look into it. You may say that false affidavit has been sworn in. We may inquire, we may ask. It's up to you, but we are not taking it for the time being. In view of the additional affidavit filed by the learned counsel by the petitioner disclosing his bank account and PAN card, the learned counsel for the, you can, if you doubt, you can proceed. We don't have any problem that this is not his bank account. This has fraudulently been created. You can proceed. We are not. You verify whether it is his bank account. No problem. Submits, learned counsel for the KAC submits that she may be granted 10 days time to complete her instruction as regards status of transport of land acquisition, as well as whether they have verified that the account actually belongs to the petitioner. It's up to you. We have given you the handle. It's up to you.
Lordship. The last occasion also, they,
No,
the same.
don't argue too much. Okay? I was in fact thinking of asking for an independent inquiry regarding who is the person behind this petitioner. You are at guilt or they are at guilt. That's why I kept it part-heard. So I have given the handle them to now.
Deeply obliged.
List this matter on.
I'm for response, my name.
Yes,
RK
RK Talukdar for NHID. Huh? 10th. Except 3 give a date. It will not take much time. One. To verify, it's up to you. We do not want public money to go waste. Yes, Mr. Vishwas.
In this case, my lord, we had taken steps and since it.
You have taken steps after the respondent being directed to be implemented.
When we filed this in 2012, this rule was not there that we'll have to make, otherwise my case. would
But
not
in
have-
CR case it will be.
CR case, yes, that.
Is not it? In a GR case, it's a
case, yeah.
different. State is represented. In CR case,
Yes, because it is filed by a private party, there is a law.
now if we prima facie not satisfied that you will not be acquitted, why should we stick onto the notice?
9, 10.
First satisfy us that.
Well,
Enough is enough since 2000,
Absolutely, 12.
2012.
Now, my lord, since it has come for orders, my lord.
Huh? That's fine. It will come for orders, be prepared. And for everybody, this court, forget about it, whether it's
Order admission. or hearing.
admission, forget about that. All cases. So come prepared day after tomorrow, Monday. If you can satisfy that this is a case of acquittal in exercise of power, we will then take a note and we'll get the service completed by 10 days. That we know how to do it. And we'll monitor this case regularly.
That's wonderful, man.
Okay?
In that way, things will also. this
No,
pendency will
for
come.
that we need cooperation from the lawyers
Absolutely,
also.
we'll-
Only bench cannot do it. We need cooperation from the bar.
On Monday, my lord,
And
I'll-
see, for this matters, a special bench is constituted.
Absolutely, I can understand.
And it is wastage of time. This court would have been decided at the admission stage itself. Monday, 25th, on the prayer of Mr. Bishas, let this matter be listed on 25th. Let us see.
I'm deeply obliged.
If you can satisfy that, no, it's a case of acquittal, then we'll consist on the notice.
I'm deeply obliged. I hope I'll be able to say.
Yes. I'm open, always open. My mind is always open. Yes. Yes.
May please, your lordship, this is for quashing lordship of a complaint case, lordship.
Uh,
That is registered under section 406, lordship.
Where is that?
Lordship, that is, complaint is at
Service is complete, no? This
Yes,
is CR case, okay. Complaint is at
page 13, lordship.
page
13, lordship.
30.
13. Lordship, that is, lordship, file against all the family members, lordship.
And under section?
Under section 406, lordship, by 506. All the husband, brother, brother's wife, sister, all, lordship. 14 is the party portion, lordship. First paragraph. At the time of marriage, my family members of the complainant gave her all the articles stated in the list as gift. And after the marriage, the complainant handed over once all those articles to the accused number 1. Only accused number 1. The list of the articles is annexed here with the accused.
Number 1 is Habul.
He is the husband.
What is the present status? You guys are any stay?
Stay is their lordship,
Hmm.
but thereafter, no contract with the client lordship. The record is also there, here lordship.
Where is the order of cognizance?
Page 25.
Page?
25.
Any statement under 200?
Yes, please.
Page?
Page 21 is the statement. lordship.
This could have been a case under 498A.
Take Lordship, before that, 498A case was lost, Lordship, and petitioner brother was arrested. Thereafter, Lordship, I filed a complaint against.
Where is those the facts?
Yes, Lordship. That complaint
And
is,
what happened to the 498A?
I have no instruction, Lordship. In fact, my complaint is there, Lordship, a page 30, Lordship,
Page
30. Thereafter, that was sent to the police and police registered a case under
page
section
30.
30. 384 and 323 cases registered.
What was your allegation?
Allegation, Lordship, that 323 and 384, extortion and Lordship retaining also there.
Now, where is the 498A?
That is, I have not annexed, Lordship, only I have made a statement, Lordship, in my application.
Where is that? Any case number?
Yes, case number is paragraph 5, Lordship. Page 5.
This is admission, na?
Washman, Lordship.
Washman. This has already been admitted. The present application under section 480, present application is filed assailing a complaint case being CR case number 669
I
slash.
not admitted, it is notice issued, I think.
Okay, under section CR case number 669 slash 2011 filed by the respondent number 2. Respondent number 2. Full stop. Respondent number 2 is the husband of petitioner number 1. Full stop. The aforesaid CR case was lodged primarily alleging misappropriation of Sridhan. Full stop. Accordingly, misappropriation of Sridhan. Sridhan. Stop. The Sridhan. Petitioner, others are also petitioners.
Yes, Lordship. All.
Petitioner number 2 is the brother of
Petition number 1.
petitioner number 1, comma, full stop. Petitioner number 3 who
The wife of petition number 2.
is the wife of petitioner number 2. Petitioner number 4
Is the sister of petition number 1.
4 is the sister of the petitioner number 1, and petitioner number 5 is
Daughter of petitioner number 4.
daughter of petitioner number 4. Full stop. A reading of the complaint discloses that the primary allegation is against the petitioner number 1 / accused number 1, that is husband of the complainant / respondent number 2, is not it? It is her case that it is the case of the complainant that she married to the petitioner number 1 on 20/06/2011, and at the time of marriage, her family members gave her different articles, list of different articles, which were detailed in the list of article annexed, pleaded in the said complaint petition. Full stop. An omnibus statement is made that the accused person have used and misappropriated those articles of the complainant and it is apprehended that they might sell the articles, thereby causing damage to those. Full stop. After receipt of the complaint, the learned magistrate recorded the statement of the complainant under section 200 CRPC, which also reflects that the allegation is against allegation so far relating to misappropriation of Stridhan is against the accused number 1, not against the other accused. Full stop. In the considered opinion of this court, if the aforesaid, if the complaint and the statement recorded under section 200 CRPC are accepted and taken to be correct in its face value, in the considered opinion of this court, no case under section 406 CRPC is made out against the petitioner number 2, 3, 4, and 5. Full stop. The statement against them, there are only omnibus statement, and on the basis of such statement, magistrate could not have taken cognizance of commission of offense under section 406 IPC 406 and
506.
406/506 IPC against the aforesaid accused person, that is accused number 2, 3, 4, and 5. Full stop. It is also on record that it is also on record that alleging similar it is also on record that prior to lodging of the complaint, the petitioner, the respondent wife, filed an FIR before Bhangagar police station, is not it?
Brother of the complainant.
A brother of the complaint lodged an FIR before the Bhangagar police station, which was registered and numbered as Bhangagar PS case number 20/2011 under section 490A of Indian Penal Code. However, the learned counsel for the petitioner is not aware of the fate of the aforesaid case. Be that as it may, for the reasons recorded herein above, this court is of the view that the petitioner has been this court is of the view that this is a fit case where the complaint is required to be quashed. So far, the same relates to accused number 2, 3, 4, and 5 in CR case number 669/2011. Accordingly, the present revision petition stands allowed by setting aside and quashing the complaint case being CR case number 669/2011 and the order of cognizance dated 27 to 2012 against the accused number 2 Babul Dev, accused number 3 accused number 2 Babul Dev, son of late Barindra Dev, accused number 3 Mamon Dev, MAMMONDB, Mamon Dev, wife of Babul Dev, accused number 4 who is Suma Sen.
Suma is the sister, Lordship.
Suma Sen and Sri Jaya Nandi are set aside and quashed. Full stop. However, it is made clear that this court has not interfered with the complaint. So far, the same relates to the husband, Abul Dev.
Regarding husband, Lordship, I have a submission, Lordship.
Yes.
Stridhan property, Lordship. Her allegation is that I have misappropriated Stridhan property.
No statement that he has entrusted to her.
And another
That I was also thinking.
Another point is there, Lordship, Stridhan property or the gift which was given during the time of marriage, Lordship, that does not constitute under section 406. There is a Supreme Court judgment, Lordship.
Okay, Suhas. I think in the meantime, everything is settled.
Perhaps because I have no contact with him, Lordship, that address then in the petition, Lordship.
Paragraph?
Paragraph 59.
That is what I was thinking, but
And effect dowry lordship.
dowry part is here because dowry part is already registered.
Dowry is also not come under 406. That is also judgment is there.
So that's correct, but dowry part we are not going because this is not under 498, is not registered. There is some allegation already, so we are not going to that. Page 50, paragraph
Paragraph 59, lordship.
59.
Sorry, 57.
57.
57.
What is the present status? Have you returned it? Any statement?
Statement is there, lordship. In my petition, I have given statement, yes.
This is the difficulty. Wife is not here. You are also not with instruction.
Hybrid council is appeared, lordship.
Yes, where is your statement?
Lordship, paragraph 8, lordship. Paragraph 9 of my petition.
Can you have any contact with your client?
Lordship, that's the difficult.
No address, nothing.
Yes, I have sent letter also, lordship, but I have not received any reply. At present, no street-on articles are left in the house of the petition number 1.
These are factual assertions. That is the problem. Factual assertions. An allegation is there that these were the articles you have misappropriated. For the complaint,
Entrustment and
See,
only one line. That
one line is there, but she has specifically stated that these are the list.
Yes,
And
list
list is there. This is the list. This is my husband. They have misappropriated. And for Quasman, nothing is not it. We cannot go to that factual assertion at this stage.
But whether that articles
Okay,
are
let him face and let them that may be close by for you. That is where I have a little doubt. Yes, that if she would have been there, then fax is admitted that yes, that has been returned, or there may be some process where there is any order of nothing.
I can only record, lordship, regarding.
She is also not there. The
CRT.
difficulty of a judge.
But whether these articles come under section 405, lordship, offense under section 405. Those are articles given at the time of marriage.
But if that is your argument, that we understand. But this is not a, see, here case was different. He said that I am giving you 25 lakhs or grant of divorce. That is 3 times the Sridhan. Isn't it? 3 times the Sridhan, I'll divorce. So court says in that context that par said this is an obitar, kind of obitar, a gift made to the bridegroom or his parents, whether in accordance with any custom or otherwise, also would not constitute any offense under 406 of the code. Then whole thing is gone.
It is like their custom, perhaps.
Maybe this is, if then 406 is, or there will be no 406 so far relating to misappropriations of Sridhan. Isn't it? If we go by this, then there will be no cases under 406. So let him face the music for non-appearing, non-information.
Since long time, lordship.
What is
After.
this?
Obligor.
I was also, while reading, I was thinking that, but problem is that if we go by this, then it will be a law. What, in what context that has been passed, that is a different.
Record lordship that may be returned.
LCR be returned back. রাখি তো বলছেন, এই citation to লিখি তো দিয়া।
Obliged lordship. এটা কোন হবে? Kindly.
Yes, Mr. Chaudhary.
This case is also the very old case, my lord.
Maintenance of 400.
Maintenance, my lord.
See the wastage of judicial time. That too in a revision, board court appeal.
No, my lord.
Huh? This is
No,
straight
but
to a revision.
For Court of First Class Magistrate, my lord, Magistrate First Class held that she is not entitled to maintenance, only her daughter is entitled to.
Okay.
She is not legally married wife.
Now what is the present status?
Presently, my lord, I don't have any contact with the client. Since last.
Was there any stay?
I
So
think-
400 paid to whom? Where is the order of the magistrate?
My lord, at page 15, my lord. 400 to the daughter, my lord. See. And she was also 17 years at that time. Now she more than 35 years at present.
That is page at page 26, isn't it?
Yes.
Impugn order.
Order is at. Yes, my lord. Criminal motion that this is 26. Finding of the
Where is the finding of the learned judge?
at page 34.
Page
34.
34. No, not 34.
34, my lord.
That is ordered at 27/6/2013. Hailakandi.
Yes.
First class, that is,
Criminal motion, my lord. It is criminal.
no, criminal motion is a sessions court's order.
Yes, ma'am.
Sessions court's order was a revision against order dated 27/6/2013.
Yes.
Isn't it?
Yes.
What is the order, disorder?
My lord, the maintenance case order that was Miss on case number 6 of 1999 is at page 15.
Page,
And against that, my lord,
page,
page 15, my lord.
15.
15.
Okay, where is the operative portion?
Party portion at page 21. Point number 4, in view of the discussion of point number 2,
Page
page 21.
21.
Third party is not legally married wife of.
So no maintenance was granted.
That has been, daughter was granted only 400 rupees.
400 rupees to the daughter, first party filing of this case. Now, in the meantime, first party has attained majority. Then criminal revision petition was filed and it was allowed. Isn't it?
Allowed in respect of mother,
Daughter, isn't it?
yes.
In respect of daughter.
Daughter, not only in respect of daughter, the finding of the court below that was reversed, not reversed.
No,
but,
no,
another-
you came before this court by
Against-
criminal revision 250/2002.
against the criminal.
Then what happened?
Thereafter, I have no contact with the,
No, see, kindly come to page 24.
when yes, ma'am.
See, what I could understand is MR case number 6 of 99 was filed by for maintenance. Okay. The learned magistrate granted 400 rupees to your daughter. You claim her not to be your daughter. Anyway, so 400 rupees. Then you file a revision 250/2002. Is not it?
Yes.
Saying that my daughter has already attained majority. So revisional court, this court says, okay, since he is
Division was not filed by my mother. I am Sushil Dhar, and my wife went to the, she filed the revision. Division she filed because she,
no, kindly come to page 22, Mr. Chaudhary. You are Sushil Dhar.
Sushil Dhar,
Is that this is by you?
criminal revision petition. Malade, there are
See, I will tell the story.
two revision.
I am better prepared than you, sorry to say. So you preferred saying that she is already measure. How can she be granted maintenance? This court upheld your contention and said, because one part was in your favor, wife was not granted, only daughter or son was granted. So you came before this court saying that, see, this is a mistake because she is a measure. Then court says, okay, she is measure, but from filing of till she attained majority, were directed to be paid. Okay. The wife now goes to the sessions court saying that I am also entitled. Is that it?
Her case, Malade.
Then in her case, it was allowed. And she was said that entitled to be paid. And the session just said that marriage, legal or illegal, cannot be determined in a proceeding under section 125. Is that it?
That is not the finding of the session.
Where is that?
Finding is there, my lord, that we got, I could not prove. Finding, my lord, at page 30.
Where is that?
Page 34, my lord.
Page 34.
I am reading, my lord.
Yes, read it.
On careful perusal of the evidence on record, it transpires that the part of findings of learned judicial magistrate rejecting the prayer of the petitioner revisionist for maintenance has been tainted with the material illegalities in as much as the said finding has not been based on the evidence on record in the case. It is in the evidence of the witnesses of the first party revisionist recorded in the case that marriage between the first party and opposite party second party was performed in the year 1980 by an informal way, but subsequently their marriage was performed according to Hindu rites and customs, and such marriage was performed by PW5, who in his evidence has admittedly stated that he performed the marriage between the parties but without observing the religious formalities. In fact, this fact stated by PW5 coupled with the facts stated by other PW, particularly by PW1, that her marriage and with the second party, opposite party, was performed in the year 1980.
Just a minute.
In 80, while second party, opposite party was working as a constable at Hailakandi police station, and due to non-observance of religious formalities, their marriage was subsequently performed by PW5, who is a priest, and this fact stated by PW is considered sufficient material to show that there was some kind of marriage between revisionist first party and opposite party second party, and as such, revisionists acquired the status of wife of the second party. So the marriage, what was the finding of the first class judicial magistrate? That finding was that it was not made as per the Hindu rites and religion. That has not been reversed here, but
that has not been reversed here, but says they are staying together. And 125 proceeding, no, nothing more is
from
required.
that point of view, the
You don't have any case.
subsequent stage law have been developed.
Develop. So we are dismissing this right now.
Yes.
Just I am asking for a judgment where this point is dealt with. Heard, Mr. Chaudhary, learned counsel. Also Mr. Bhattakur, learned Spencer Spencer. None appears for the respondent number 2. The present application is filed under section 482 of the Code of Criminal Procedure 1973, assailing an order dated 27/6/2013, passed passed in MR within bracket EX number 53/2009, passed by judgment dated 14/11/2007. Not MR case, application, assailing an order dated or assailing judgment dated 14/11/2007, passed in criminal motion number 70/2002 by the Session Judge Hailakandi. The further challenge is an order dated 27/6/2013, passed in MR within bracket EX execution, MR execution number 53/2009 by the learned Chief Judicial Magistrate for execution of award passed by the learned Session Judge in criminal motion number 17/2002. The brief fact leading to filing of the present case is recorded herein below. The respondent number 2 filed a complaint under section 125 CRPC before the learned Chief Judicial Magistrate Hailakandi, claiming maintenance for herself and her female child, which was registered as case number 6M/1999. The present petitioner contested the aforesaid case by taking a plea that she was not a legally married wife of the petitioner inasmuch as the petitioner, inasmuch as on her complaint a departmental proceeding was issued against the petitioner and he was dismissed from service on 24/05/1983. However, subsequently, he was reinstated in the service on the for the reason that the petitioner could not prove a valid marriage between for a reason that the complainant could not establish a valid marriage between the petitioner and complainant. Thus, it is the case of the petitioner that as the marriage between the petitioner and the complainant was not valid, the learned, not valid, and therefore he is not entitled for payment of maintenance under section 125 CRPC. After considering the evidence on record, the learned trial judge, that is Chief Judicial Magistrate, by its judgment and order dated 4/2/2002, declined to grant maintenance in favor of the complainant being not legally married wife. However, declined to grant maintenance in favor of the complainant, holding that there was no valid marriage, that the petitioner and the complainant is not legally married husband and wife. However, the petitioner was directed to pay a maintenance allowance of rupees 400 per month to the minor daughter, to the daughter. Full stop. The present petitioner, being aggrieved by the aforesaid order, preferred a criminal revision petition before this court, which was registered as criminal revision number 250/2002. Full stop. Said criminal revision petition was disposed of by this court under its order dated, which order? 23/5/2006. Holding that in the meantime, holding that the child has in the meantime attained majority on 30/4/2000, and therefore the petitioner shall not be liable to pay awarded amount beyond the said date, that is 30/4/2000. However, he is liable to pay maintenance to the daughter with effect from 28/1/1999 to 30/4/2000. Full stop. The complainant wife, being aggrieved by the determination made, aggrieved by the judgment dated 4/2/2002 passed by the judicial magistrate, chief judicial magistrate, approach the learned session judge, which was registered as criminal motion number 17/2002, and the learned session judge Hailakandi, by its judgment and by its impugned judgment, dated 14/11/2007, passed in the aforesaid criminal motion number 17/2002, directed, reversed the decision of the learned chief judicial magistrate and awarded and maintenance of rupees 500 per month to the complainant wife from the date of the filing of the petition under section 125 CRPC. Full stop. Subsequent to that order, when amount was not paid, the complainant wife approached for recovery of the said amount, which was registered as MR EX 53/2019, and by impugned order dated 27/6/2013, the learned chief judicial magistrate Hailakandi issued warrant to realize the arrears due to the complainant. Full stop. Mr. Chaudhuri, learned counsel for the petitioner, while assailing the judgment dated 14/11/2007 passed by the learned session judge, argues that the learned session judge, in exercise of its revisional power, ought not to have interfered with well-reasoned judgment of the learned chief judicial magistrate, who had arrived at its conclusion after proper appreciation of material evidence on record. Therefore, such order is liable to be interfered with by this court. Full stop. Full stop. None appears for the complainant plus respondent wife to defend her case. Be that as it may, it is seen that the whole case, the fundamental ground, fundamental case of the petitioner is that the complainant was not a legally married wife of the petitioner, and therefore she is not entitled for any maintenance under section 125 CRPC. It is the further case that the learned Chief Judicial Magistrate, after proper appreciation of the evidence, has concluded the such context has arrived at a conclusion that the marriage was not a valid marriage, and therefore such conclusion ought not to have been interfered by the learned session judge below. Stop. Such the issue should not detain this court any further, inasmuch as Honorable Apex Court in Dwarika Prasad Satpathy versus Vidyut Prabha Dixit and another reported in 1999 7 SCC 675 laid down the proposition that the standard of proof of marriage under standard of proof of marriage in a proceeding under section 125 CRPC is not as strict as it required in a trial of an offense in a criminal case. It is equally well settled that an order passed in an application under section 125 CRPC does not really determine the rights and obligations of the parties, inasmuch as section 125 CRPC is enacted with a view to provide summary remedy to neglected wife / children and parents to obtain maintenance. It is also well settled that absolute proof of marriage is not always necessary, and when a party denies the marital status, he/she should opt for the appropriate remedy to establish the same. Next. Next paragraph. The object of revisional power under section 397 CRPC is to set right a patent defect or an error of jurisdiction or law. Such power can also be exercised where the decision under challenge are grossly erroneous, there is non-compliance of provisions of law, the finding recorded is based on no evidence, material evidence is ignored, or judicial discretion is exercised arbitrarily or perversely. Full stop. Now coming to the determination made by the learned session judge. Now coming to the determination made by the learned session judge, it is seen that the learned session judge, where is that judgment? Page 34, is not it? Page 34?
34 is the finding.
34 is the finding.
There is another statement in this. Stated that an evidence that she married to someone Niranjan Das, and that has been discussed by the
We are coming to it. The learned session judge, while reversing the decision of the Chief Judicial Magistrate, had reappreciated the evidence laid by the complainant as well as the petitioner. and came to a conclusion that the decision of the learned chief judicial magistrate was tainted with material irregularities, inasmuch as the said findings has not been based on evidence recorded in the MR. And accordingly, the learned session judge reappreciated the evidence and came to the following conclusion. One, from the evidence of the witnesses of the complainant, it is established that the marriage between the complainant and the petitioner was performed in the year 1980 by an informal way, but subsequently their marriage was performed according to Hindu rites and custom, and the said marriage was performed by PW5. And the said PW5 in his evidence has stated that he performed a marriage between the parties, but without observing the religious formalities. Such fact coupled with the facts stated by other PWs, particularly PW1, constitute sufficient material to show that there was some kind of marriage between the complainant and the petitioner herein, complainant and the alleged husband. Two, there is no hard and fast law that a woman, in order to become wife of the petitioner, must perform her marriage by strictly following religious teachings. Third, there are ample materials in record to show that from 1980 to 1982, the complainant and the petitioner lived together as husband and wife and resulted in delivery of the minor daughter, and in whose favor already maintenance allowance has been granted. Though the husband, through his evidence, tried to prove that the complainant has in the meantime married to one Niranjan Das, there was nothing to prove such fact. Full stop. And accordingly, it was concluded that the determination made by the learned chief judicial magistrate was perverse. First of all, this court has also perused the material available on record in view of the determination, in view of the conflicting determination made by the courts below. After perusal of the said material, backed by the settled proposition of law that strict proof of marriage is not required under provision of under a proceeding under section 125 CRPC. This court is in total agreement with the findings recorded by the learned sessions court below, inasmuch as such determination is based on sound reasoning. First, in the considered opinion of this court, and as discussed herein above, the learned Chief Judicial Magistrate has failed to duly appreciate the evidence on record and gave undue emphasis on the strict proof of marriage. And therefore, such determination is such determination can be termed as a patent defect, and therefore this court find no infirmity in the determination made by the learned sessions. Accordingly, the present petition stands dismissed. Interim order, if any, stands vacated. In view of dismissed LCR, asana? The LCR will be returned back. Yes, I know. Yes. Yes, next case. Revision kita শেষ করলাম, passing করলাম। Yes, Mr. Sigdar.
Here we are appearing for passing of the affair.
There is no stay. Then what happened? What is the present status? Seated. Huh?
Well, there are two cases has been filed out of the same incident.
Huh.
In one case, trial was concluded and the accused were acquitted.
Where is that?
That judgment, I am also having my lord.
Any statement in this petition as regards that?
That affair, both the affair we have annexed here. The first affair was the full PS case number.
Where is the first affair?
What you will find at page 37. 37 to 40.
37
to 40. That was the first affair, and in that case we had acquitted. 37 to 40, 42 months. 42 is the Farani report. 37 to 40.
So 37 to
40, my lord.
38.
38, my lord. No, my lord. There is initially it was complained before the deputy commissioner, and deputy commissioner referred
So
to
it is under section 40384 IPC, Hatigao case number 28113.
Yes, my lord.
In that case, you were
Acquitted.
acquitted.
Acquitted, my lord. And the second affair we have challenged.
Just a minute, where do you get that this is the case? FIR?
Second affair, my lord.
Okay. This is Hatigao, PS case number 281, 2016. Now let us come to the second affair. Where is the second affair?
Second affair. That is at page 24. 24 is the type copy.
The type copy is at 29?
Type copy is 24.
24?
And photocopy at page 26.
24.
Same allegation that they are egg merchant, they are taking
Mr. Bothapur, take an instruction. What happened to this case?
Yes, madam.
436 of 13, Hatigao.
Yes, madam.
At 2?
Yes, madam.
At 2. We'll take up at 2. Okay. Or if you can have it before 2 also.
Yes.
Just have it, right? See, similar allegations.
My lord, otherwise, my lord, because that at that point of time, my lord, FIR was challenged. So now in that case already acquitted.
Acquittal,
So what
nothing,
happened in this
it is,
case, my
that's
lord,
we want to
that
know.
trial
Even
is-
if it is Sarsites file, we will say that similar order
Yes,
cannot be.
Yes.
Exactly the same allegation. Okay, just you have it. You, if you possible, take this. Yes.
yes.
Now, how many matters left? Okay, I will have. Yes.
It is a 483 application on lordship. Associated matter lordship. Commissioner behind the by agenda lordship 1607 days lordship. And already Sarsit lordship and trial is commenced lordship. Out of 9 PW's lordship, CS6 already examined learned trial court lordship. Next day is today fixed for PW7 lordship.
Which PW7?
PW is Dr. lordship.
Today he has come.
Then trial court next day fixed for today.
Huh?
So say today it's fixed for examination of PW7 who is a doctor lordship. Trial court whether he's come on not trial lordship.
That is what I wanted you. He is the only witness to be examined. He is the only witness to be examined. Ayo.
Remaining two others. that is
Ayo.
lordship. Already victim and informant and other individual witness also already examined.
Be there for some time so that you can get an interim order at the time of admission of the appeal. Sure sort of case of conviction. Why you observe something at this stage from us?
Because
Only 3 witnesses are there. We'll have to grant you only for the time and we'll have to discuss what the PW1 says, victim says. Why are you inviting?
more than 4 years he is behind the bar lordship.
You want to be there for 10 years? Huh?
Lordship.
We are rejecting it.
Only consider lordship the
Here is no question of kindness. Here is a question of law. Whether in view of the evidence, Sarsited case, already materials available on record, this is a case for grant of bail. If we say this is not a grant of bail for this so and so forth reason, then even if we observe that it should not influence, then also there will be an influence.
But not influence already 6 PW are already examined. There is no chances of
You are not getting
tampering
what
the evidence.
I am saying.
He is a local person lordship. He appear next date every date lord. He is a local person lordship. No chances of hampering or tampering the evidence also lordship.
What is the ground for granting a bail during the trial? What should be the consideration?
If there is a law paper, there is
No,
there
tell
is-
us. Tell us what should be the consideration for a court to exercise its power for bail. What are the criteria and parameters and principles?
If it is
What
married,
are-
then
Huh?
if it is married, then the court can exercise lordship.
If merit. So
Yes.
we will have to enter into the sum of the prima facie merit of the evidence of the PW1.
Contradiction also in their statement.
So you are asking us to go, it's moment we reject it. Then at this stage, you are already for 4 years. Be there for some 3-4 months. Then pray that already I have been in all throughout 4 years. There are materials against you. There, of course, there might have been some relation, but she is a minor.
Is other she is
That she is minor has been established by evidence prosecution. Now what comes is that whether you have done the act or not. Now under POCSO, the burden shifts to moment AG's foundation is laid down. It shifts upon you. And we'll have to consider all those things here. You are still not getting what I am expressing. What is the next date?
today lordship.
Have the information.
Examine or not having. Then let them next date lordship. I will produce the PW
Okay, when?
next week lordship.
Okay, on the prayer of the learned counsel for the petition. Come prepared, come prepared. If you press this, then we'll have to answer. We may go in your favor, no problem on that. But not saying that I will not hamper and temper. This is not the ground in a case. I will appear. This is not a case. List this matter on the prayer of the learned counsel for the petition. List this matter on 28.
Much obliged.
What are the other persons who are granted bail?
Two persons granted bail.
Huh?
Lordship. Other two persons granted bail.
One is
One is Lulung Kuki and
Lulung was granted on hell ground.
Yes.
Okay, forget about him. Then
Amkhon Jin.
Kamkom Singh was not arrested from the vehicle.
Yes.
But
Then how is your case is similar? Huh?
not similar, Lordship. On the basis of the statement of these persons, those two persons arrested on the same day.
No, Kamkom Singh was arrested from another place near downtown
Downtown.
on the basis of information statement of this victim, and we said that their statement nothing material against them. So therefore, we have granted Kamkom Singh.
My lord.
Now this Lalung and Kamkom Singh are appearing in the trial court.
Yes. But Lulung Kuki, I think to our information,
Lulung Kuki is
Is absconding.
absconding because he was ill health. To our information, he expired, Lordship.
Okay.
That is the reason. And during that
Now
period,
what is your case?
my case is something.
What is your
different.
ground?
My ground, Lordship, before going to the entire ground, Lordship, kindly note the date, Lordship. He was arrested on 28,
Just a minute.
29.
Arrested on
29/8/2021.
29
8
8
2021.
2021. Then
Then Lordship, in this case, charge sheet submitted and then
charge sheet submitted when?
charge sheet submitted on Lordship. On 20. I'm giving that date, Lordship. 29/8/2000. 29/8/2021.
No, that is the arrest. 8/2021.
I'm giving Lordship. Then after filing of charge sheet, Lordship, charge frame on 9/3/2022.
Charge
Frame on 9/3/2022.
9/3.
9/3/2022. Then
What happened in between?
in between, Lordship.
When, sir, that was the important. Charge sheet was filed when? When the matter was sent for trial and when trial commenced. These are vital.
7/11.
Because your whole ground is the delay, nothing more.
7/11/2021.
7/11/2021. Okay, then
Then charge frame on 9/3/2022. So thereafter, Lordship, three witnesses examined, Lordship.
till now, how many witnesses examined?
Total 9 witnesses.
Total listed witness,
9.
listed 9 witness. And
Thereafter, Lordship.
listed 9 witness,
nine witnesses.
examined
Examine only 3 witnesses. 3 witnesses, Lordship. Among 3, Lordship, PW, one is the FSL expert. Obviously,
PW1 FSL,
FSL. Then 2 Caesar witnesses.
PW2,
PW2 is Lordship Caesar witness Virat Lamgad.
and PW3
PW3 is one of the Caesar witness.
Caesar witness.
Yes.
Okay, let us see what is
Deepak-
this.
Deepak Singh. I have Xerox all this. I have made a copy, Lordship, of the deposition of the witnesses.
Give us that.
Yes.
Then this, in presence of these seizure witnesses, I'm on that, Lordship. And the last witnesses examined on 23/8/2023.
Last examined on
23/8/2023.
23/8/2023.
Yes.
Thereafter, no examination.
No
Why?
examination till today. There are no reason cited, Lordship.
No,
Because
did not appear.
no, someone, yes, someone issued, nobody appeared. Yeah, and he is behind the bar for about 3 years, 2 months, 22 days today. So I would like to place the deposition of PW 2 and 3. They are the seizure witnesses. Nobody has named the persons, and the cross is also quite different, Lordship.
Next.
Tulung, okay. Photo.
What happened after his cross-examination subsequently?
Subsequently,
Who is accused number?
Lordship.
Your name is, your accused is?
Pao Min Thang.
Huh?
Pao Min Thang. Pao Min Thang Hal Langhal. Langhal.
Who are the other witnesses for
Lordship, they are the witnesses, Lordship. These two are the seizure witness, and then Lordship, other SI Rajkumar Tai, and then Subhana Banu. She is also one of the seizure witness, and Navajyoti Garo, seizure witness. These are the seizure witnesses of the Whiteman and all these things, Lordship. These two are the main witness, Lordship, who had stated that that's in cross. Lordship, first PW2 cross part is very interesting, and the PW3 also. May I read?
Yes.
Police did not seize any document to show that I was detained to do duty at Nazira Khat Toll. I could recognize the police personnel of Sonapur PS but could not recognize the other police personnel. Police asked us to keep on vigil of vehicle coming Nagaland, Manipur.
He is a policeman or an employee of toll gate.
He has stated that he is the employee of the toll gate at that particular point of time. In the first line of the chief, it is written, I was on the duty of Naziraghat toll gate. So, but no specific registration number of any vehicle was given to us. I do not know the names of the person who were traveling by the intercepted Bolero vehicle. The vehicle was parked within the range of the CCTV camera of the toll gate. Initially, the bodies of the persons traveling by the vehicle were searched and they were made to kneel down, and thereafter search was conducted inside the vehicle. I did not state to the IO whatever I stated in the court today. I do not know the content of the exhibit P3, the Caesar list. I have not seen the suspected drugs in the court today as asked by the police. I put my signature in exhibit P3. It is not a fact that I have deposed Wasi. These are the suggestion, Lordship. Then kindly turn to the deposition of PW3. May I read, Lordship? So his cross part is also very interesting, Lordship.
Yes.
So cross
So
part,
what do you say? I have read the cross parts according to you.
Lordship, because he has a visiting term with the police. Police said that these are the some persons were there, and you put your signature.
That is PW3.
PW3.
Now what
And
about PW2?
PW2 also he has stated that contents of the exhibit 3.
See, during cross-examination, he has reaffirmed that initially their bodies were searched and thereafter vehicle was searched. Vehicle was searched.
Vehicle was
Okay, in the cross-examination. In the CIF also, he has said that vehicle was searched and so boxes were recovered from the vehicle.
No, he has not stated as
No,
from-
cross, you will not say. You have not asked any question.
So
You have not given a suggestion that was recovered from the vehicle. You have not given any suggestion that these persons were not present, witnesses present were not present in the vehicle.
He has not mentioned the name of the person.
No, how will he mention?
My lord, because he is the Caesar witness, Lordship.
See, do you propose to say that Caesar witness must know the name of the
Yes.
offender?
But on the basis of these witnesses,
No, see, what he has said, please answer it.
yes, yes.
In his CIF, he has said that I was in such and such place. You have not disputed that you were not in such and such place. Okay. Only thing you have disputed that
So we
there
have
was
disputed, Lordship.
no, you have disputed only that you did not have any identity card.
No. It is not a fact that I was not an employee of Naziraghat toll, and it is not a fact that no such occurrence took place as deposed by me.
Okay, as deposed by you. Now, according to him, he has recovered some soap boxes containing suspected drugs. Police took signature in the spot and down. So therefore, would you say that a fact of recovery of some soap boxes from a vehicle, Bolero vehicle, was recovered?
No quantities, nothing, Lordship. As per Caesar list, he has stated, I do not know the contents of the Caesar list, Lordship. As police said, I have not seen the Caesar, that is, I did not state to the IO whatever I stated in the court today. The statement recorded, Lordship, in 160. Or else he could have identified he may not mention the name of the person, but it was the duty of the prosecution to identify in the doc, these are the persons who were present at that particular point of time. This has not been done and he has not identified the person.
Yes, but Thakur, see your examination in chief. Why should they cross-examine you if you have not laid the foundation? That these are the persons, these are the two persons present were in the vehicle. I do not know their name, but these are the persons. These are the soft boxes which were recovered in my presence. What recovered? He recovered, something recovered. That this is recovered is not there.
Your lordship may kindly, yes, my lord, regarding that part, my lord, regarding other things, my lord, total there are 6 accused persons. Regarding the, my lord, expiry of.
Same will happen to everybody now.
Yes, yes, this is the.
This will open
Here
the door.
Here the quantity of, my lord, heroin is, my lord.
We understand, huge,
huge
something 1 kg and odd.
1 kg and odd. And my lord,
And see, you have been examined your witnesses.
And my lord.
Last in 23rd of August 2023.
They could have finished the matter, lordship.
23rd of August. And we are completing 24th, not a single witness beyond, and this is the standard of witness. Okay, we'll pass this order. No way out.
My lord,
We'll pass.
otherwise, my lord, I am just pointing out your lordship, because in this case, huge quantity is huge.
That's
My
true.
lord, from the entire case, my lord, records, he is the main accused and one Lulum Cookie, although now she said that Lulum Cookie expired.
No.
But
This is
regarding,
my information.
regarding that, my lord, she has also, after obtaining bail, not at all appeared before the trial court. So, my lord, it is, my lord, at this point of time.
No, that's fine. That
Now,
we
my
understand.
lord,
That anxiety I am also having. My
Yes.
anxiety is that, see, we are not granting in this kind of cases bail only on the ground of delay in the case. Not always. In certain cases, we have granted the co-accused on the ground that his arrest was only on the basis of statement of the co-accused, and he was arrested near downtown hospital, something
Yes,
like that,
yes,
isn't it?
Yes,
Then
these two persons.
not
Yes, my lord, regarding Kamkhozim, my lord, he was actually from the record, my lord, I have found. Maybe, my lord, he may be a, but I am not at this point in time saying, because Lulum Cookie has used his mobile phone for getting messages from the persons who are in the vehicle.
Mm.
So now, my lord, why Lulum Cookie has used the mobile number of Kamkhozim? Maybe, my lord, I am not saying he's a scapegoat. He may
no,
be
everything will
person.
come later on.
Yes, yes.
First thing is proof that this was a if that proposition was there. That is the foundation.
Yes.
That this and your projected witness for Caesar is this 2%.
2%.
So you will have to lay the at least foundation that yes, this was recovered and this was the person. We'll see later other things.
He is the owner of a garage, the present petitioner, my lord. He is the owner of a garage. He is the owner of the vehicle.
Where is the evidence? Forget it, that will come later on.
Yes.
So, okay, that is established, he is owner of a garage, everything is done. But the foundation is that on such and such that these persons were in this vehicle,
Yes.
and from this vehicle, this is the amount recovered. I may not know this name of this person. I'm not supposed to know. I'm a bystander. How do you know their name? Even if their name is shown, I may forget.
Otherwise, my lord, yes, there are decisions long in everything. My lord, this matter may kindly after some days, my lord, your lordship may fix. I will again, my lord, because quantity is huge, my lord. Let them, because otherwise.
When tell us.
My lord,
What is the next date?
my lord, on 3rd of December, my lord.
What is the next date?
Because, my lord, till 1st of December.
Nothing will happen on that.
We know nothing will happen. Be there happy for some time. Yes, sir. When? What is the next date?
Next date, probably lordship this month, lordship. End of this.
You must be ready with the facts before this court. I'm again reminding you.
Lordship,
Facts.
whatever, one thing. I prepared a note for your lordship. Just now I saw this and it's
That is not
missing-
there.
Missing.
That is the you ought to be ready with facts that this is the date FIR flies, this is the search sheet, this is the framing of charge, because your whole case is twofold. One is the not that foundation is not laid. Prima facie, if it is accepted everything to be correct. This evidence is corrected to be, even if it is accepted that everything is correct, then also foundation is not even laid. If foundation is not laid as regards conscious position.
While my lord,
In
Sir,
conscious
say he-
position, Lordship, it's what my learned friend said regarding Lulu.
Now, what is the next date?
I'm giving Lordship. She's being back.
Okay, when Botha kon?
December, my lord. Yeah, fine,
Yeah.
5th of December, my lord, I will finish on that day, my lord. Because otherwise, my lord, this is the person, he is directly involved. I know.
See, Mr.
My-
Botha
Yes, my understanding.
problem is that we cannot go by the mental conviction.
Yes.
We'll have to go by
Yes,
the what is the material.
Material,
And of course, this is an application for bail. Is not it?
yes,
It's an application of bail. So until and unless we are satisfied
yes.
that 37 is fulfilled, I think this is a case where 37's rigor is fulfilled. That's all. We are not commenting on anything.
On 5th of December, my lord, I will finish, my lord. On that day, my
I'm
lord, if
waiting
my
for
lord,
that.
otherwise, my lord, there are Supreme Court
5th
decisions
of
regarding on.
December.
9 January, case is fixed on 9 January.
So we are fixing it on
5th of December.
5th of December. Let him have a satisfaction.
On 5th of December, nothing will happen because for evidence fixed on 9th of January.
No, he want to argue this, go through and argue this
Can
case.
it be little bit earlier?
Yes, you
Lordship?
have a talk with Mr. Botha.
My lord, because, my lord, I have some difficulty till on 3rd of December, my lord.
3rd of December.
3rd of December.
Okay? 3rd of December.
My lord, I would like to place one letter judgment in same way, Lordship, as this by the apex court. Of, on Lordship, it's
Now
April
trend is changing. Other judgments are also they are recently coming in NDPS.
15/4/2024, Lordship. 15.
Thereafter, October, November judgments are there
I'm not
in
saying
Supreme
that
Court.
this person is suffering.
So this is basically, see, Foundation 37, yes, Article 21 is a very valuable right. We understand. We'll see, suppose absolutely there is material to suggest that you have recovery is there, everything is there. Why should we go for Article 21? We'll ask them to do it.
Some vital points, my lord, yes, not those points were need to be investigated, but those points were not looked into, my lord. Regarding the owner of the vehicle, he is the owner of, and those, my lord, from the how he fitted those, my lord, drugs in the
No,
backlight.
that is also even you can bring it by subsequently, that he is the owner, so and so, so and so. But the seizure witnesses
This is the
are
difficulty.
not even saying that this is the material recovered from this vehicle,
yeah.
even in the sieve.
In such a.
Then this is the person who do those, you ought, the seizure witness may not know the name, but he ought to have said that this is the person. Who will establish that they were the person?
Yes.
That these are the
Yes.
person from recovery was made. Even it is established that a recovery is made from a vehicle, nothing is there. Whether they were present at that point of time, they have doubted,
Yes.
and there is nothing. This is the way to make a
Yes.
sieve.
My lord, in such a huge quantity of, my lord,
Use
drugs.
quantity.
Otherwise, my lord, main.
What my learned friend is.
Okay, on third.
My lord, one point is that.
No point, next on third.
He has stated that he is the owner of the vehicle, but it is not mentioned in the charge sheet, Lordship. There is no investigation. to
Let him
that.
argue there. On that day, you give a reply. Let him do something. He is also, he is, okay, give a last of this month.
Last of this month, because my lord, I have some difficulty because still otherwise, my lord, on that day, if I could not be able to present, then my lord, it would be difficult for her also.
Okay, on third.
Third of this.
Be dear person. Yes, next.
Obliged, Lordship.
Keep that note, huh? Good to know.
Please, your lordship. Lordship, my senior is in legs in another port, so.
Yes, Mr.
Matter may be
Where is
fixed
he? Call her. Give an, where is now? Yes. Give a list of dates. Huh? Give a list of dates when FIR.
Next step, next.
You can give it today also.
I'm giving.
Give it today so that I'm prepared on the next date. I can dictate the order.
Lodge.
Yes.
Lodge.
to. Tell the matter may be fixed at
Which
2.
item?
Item 21. At 2. My senior is in legs in another
What
court.
is this case? Let us see.
Appeal against equitable.
Appeal against acquittal. What was the offense?
It was a murder case, lordship.
Okay, 2. Yes. He says, no? Yes.
My senior was present here, Zed Kamar, but due to some urgent matter, he's currently in another court. May this matter be taken up at 2? We have informed the council for
Yes.
CBI.
What is 23? Twenty-one gone. Yes. 21 will call at 2. Yes.
23, my lord, my lord, yesterday I received one, my lord, call from the client that the petitioner number 1 died, my lord, in the year 2022. There is another petitioner, my lord, petitioner number 2, my lord. My lord, originally, my lord, the CGM, my lord, convicted under section 341 and punishment for 1 month, my lord. And my lord, simply imprisonment for 1 year under section, my lord, 325. Thereafter, the additional session judge FTC Bongaigaon has, my lord, partly modified the sentence, my lord, acquitted under section 341 and reduced the sentence from 1 year to 6 months, my lord, under section 341, my lord.
What is your ground?
My lord, ground, my lord, there, from the same incident, my lord, there are another cross case. I have also annexed the, my lord, judgment. In case of my FIR was, my lord, filed earlier, my lord, and that FIR was filed later on. But that judgment was given that due to the delay, my lord, of the filing FIR, she was acquitted. And one, my lord, the other ground is that, my lord, my lord, assault weapon, my lord, that is the lathi was not seized or produced, my lord. There is a, my lord, judgment of this. And third is, my lord, in 313, no, my lord, query were made that you have anything to say, my lord, in 313. No opportunity was given.
Okay. Yes.
My lord, I have gone for the evidence part also, my lord. All are the eyewitnesses, my lord. Some of the.
We'll come back at 2. We'll start this matter first. Yes, Mr. Nawaz.
Item number 8, my lord, I've just checked the records. And they have photocopied, my lord. Paragraphs are missing, my lord. So section will be perhaps.
Item number 8, copies are not legible to give properly. Item number 8, I pass this order. Now we'll add it that though copies of the evidence are given to Mr. Nawaz. Copies of the judgment and evidence has been furnished to Mr. Nawaz learned amicus. However, he submits that those Xerox copies are not legible and not properly Xerox. So, therefore, registry shall verify the copies given and give appropriate copies.
Let it be remain on for hearing on 26. If I get it, my lord.
Yes. Already have fixed a date for hearing. On that day, this will be added. Yes, we'll come back at 2. Item number, Mr. Sigdar?
20.
20. It is the present file is there. The present application under section 482 CRPC is filed for quashing FIR registered as Hatigao PS case number 281/2. Is not it? Huh?
No.
436.
436 of
Just the 436 /2013 under section 420/384/34 of IPC. Full stop. It is submitted by Mr. Bhattakur, learned additional public prosecutor, that after completion of investigation, the investigation officer has filed final form by way of a closure report being
253
being final report number
253/2014 dated 21/9/2014.
21/9/2014. In view of the aforesaid, this matter has become infructuous. Accordingly, same stands closed.
My lord, we have given a copy of the previous case judgment. It record, we part of the record,
No, I said keep it. Where you kept it?
copy of the photocopy of the
I
judgment,
wanted to
judgment of
see
the other case.
Return it back.
Okay, my lord.
Yes.
Biplab Lajdas.
Yes, Mr. Kamar. How much time will you take?
It's a DA case.
Huh?
Mr. Manos Halo for the CGI.
How much time will you require?
Definitely, my lord, 44 witnesses are there.
And
22, no? Lordship, Mr. M. Halo is in court number 18. Matter is going on, Lordship.
will it be possible to come here?
After finishing that, he will come.
Can start, I think.
Okay. So we are taking a revision method. Yes. Or some other day.
I'm ready otherwise, my lord.
No, I'm asking is
Then, because paper book is also there, that's one.
paper book is there, na?
There. So if, because that's bail matter is a lengthy matter. 4 to
Says
6,
matter.
he told me also, my lord.
So why I'm asking is
I got it.
this is one aspect. Other aspect is so many
Yeah, I
disposals,
got it, my lord. I
all
got it.
corrections and
Yes.
uploading. Letters are pending.
Because, here, my lord, I'll have to show each and everything. DA case, my lord, just to make it a reference, my lord, it's a DA case. The wife's income, who was just having a separate independent business, has not been taken. All has been clubbed in, photostat copies has been taken into account while convicting.
Why should you argue so lengthy? You point out that matter ends there,
I can, my lord.
isn't it? Instead of saying all, what is the vital foundation?
Vital
Foundation under a DA Act, whether that has been proved beyond
Yes,
reasonable doubt.
not-
If it is not, then we'll not go to the other aspects. Because there's some calculations, some procedures are given.
Yes.
How to do it, what is to be included, what not, and how it is to be proved, what should be the evidence. Highlight on that instead of.
If your lordship, for all sake, I'll prepare the synopsis, then give it.
Give it to.
I've not prepared it.
No, not today. Give it. Why should we waste so
Yes,
much
yes.
of time?
No, that will cut, I'll give him in advance also.
Give him in advance.
Yes. Next date I'll do that. Malik, can it be?
We don't have that much of luxuries like earlier days. We'll read every evidence.
Yes, not necessary also, my lord.
Not necessary. We'll point out the issue of determination
Right.
first. Then what is your argument? What is their argument?
And what is the legal flaws?
Legal flaws. So we'll see.
And
And what
I
is
have got certain judgment.
what is required to be followed
Followed.
for proof of that? That these are the ingredients
Not been followed.
followed. That's all. And whether that is fatal. That's all.
Yes, yes, very kind, my lord. That's why I'm eager to do it, my lord.
That's all.
Cut to cut. So, my lord, if it's not inconvenient, my lord, can we have it on the 2nd of December, free time? It's,
2nd of December,
your lordship is probably already one matter.
2nd of December. Okay. But before that, that synopsis or your argument before that, not on that day,
Oh, I'll give it, my lord. I'll prepare it.
with an advance
I-
copy to them and to
Give
us.
Your
also.
lordship also. And with all the legal citations.
All legal citations. Or you even you just cite it, or you can just one line or two line, what is the ratio? That's all. That's
That's very,
And what are the important provisions of Evidence Act or whatsoever you are relying on, that this is should be.
absolutely.
Then we'll do our thing here. And what we are proposing is of course, we'll have to go, this is an appeal, isn't it?
Appeal.
So we'll have to go every evidence. That is a different, but while hearing you, we'll dictate and record. Once you will read it, again I will dictate it. This is not. We'll read together and dictate it. The evidence part.
Also.
Yes.
That will be more beneficial. for
Okay.
us. More detail.
Okay.
One second, my lord.
Yes.
Second December.
Yes.
With your lordship, probably this matter may take time, lordship. So lordship, I am for item number 21, lordship.
Mm.
In this case, lordship, two appeal file arising out of same judgment, lordship.
Okay.
Acquittal, lordship.
Mm.
This honorable court by division bench dated, lordship, 11/8/2022, lordship.
Mm.
Already disposed, lordship.
Uh-huh.
Two appeal file, lordship. All the respondents same, lordship, against acquittal, lordship. One is filed by injured victim and other is mother, lordship. Injured victim file, which was disposed, lordship,
Disposed by,
by a division bench of our dishonorable
then what was that? It was dismissed.
allowed, lordship.
If it is allowed, this will also be allowed.
Lordship.
Give us.
Respondents.
Therefore, respondent lordship.
Why it went to division bench?
Because lordship, as per High Court rules, lordship, if he is acquittal under section 302, then lordship matter before division bench, lordship.
And in each case, why this is in single bench?
I don't know, lordship. Probably
So should it go to the division bench?
Exactly, 302 is there
lordship.
and
Chapter 7,
paperwork has not been prepared. I did not get any.
No, the matter ends there. 2 appeals, one is already allowed.
No, that.
This morning I came to know about this lordship,
Our division bench
division bench.
or other accused person.
No, same, accused person same, but appellant different. One is as one mane apnar
Bimola the
Bimola informant, mother.
Mother.
Aru hetu injured asil Torun Das.
Initial convict, it was case of acquittal.
Lordship,
Against acquittal, appeal preferred by two persons.
Two
One is informant, one is victim.
lordship,
Appeal preferred by the victim is allowed or
Lordship.
dismissed.
allowed lordship.
Allowed. By allowing remanded.
No, lordship.
This was conviction.
No, lordship. In
Upheld the
Upheld,
acquittal.
upheld,
the
Upheld the acquittal.
Upheld the acquittal.
So if it is upheld the acquittal,
Lordship.
same fate will be
Acquittal.
Huh?
I have also come against the
acquittal. So nothing remains.
Have to be same fate, my lord.
We can close
Lordship,
it.
close it, lordship.
Or you can say that this nothing survives in view of the division bench passing this order.
Lordship.
I can submit this. my
Okay.
lord.
The other, instead of going to the division bench and all, we'll say that you will close it in view of that order pass.
Lordship.
Full stop. Sorry, Mr. Biswas, learned counsel for the petitioner, also heard. You are Mr.
IU Chaudhary. My name is not there, lordship. On behalf of HRA Chaudhary, lordship.
Mr.
IU Chaudhary.
IU Chaudhary on behalf of Mr. HRA Chaudhary. Mr. Hazarika is there in.
Lordship.
in-
Today he is probably not there, lordship.
Okay. Full stop. I'm sorry. Full stop. The present appeal. Oh, this is criminal revision. That's why it is here.
Lordship,
Where is
appeal,
that? Okay.
both appeal.
194. Okay, 194.
Both
The
appeal.
present appeal is filed against judgment and order dated. Mr. Biswas, please verify, huh?
30/04/2011.
34, 2011.
34/2011, passed by the learned additional district and session judge FTC Karimganj in session case number 49 of 2009, by which all the accused persons were acquitted by giving benefit of doubt. Full stop. The present appeal is preferred by
By mother.
the informant mother. Full stop. Mr. Biswas, learned counsel submits that the one of the injured victim
Lordship.
also preferred
Torun Das.
injured victim, Mr. Torun Das, had also preferred an appeal against the judgment and order dated 34/2011 against passed in session case number 49 of 2009 against such acquittal, and said appeal, criminal appeal, was registered as criminal appeal number 43/2012. Full stop. It is further submitted by Mr. Biswas that aforesaid appeal has been dismissed by a division bench under its judgment and order dated 11/8/2022, upholding the judgment, upholding,
There are 64, lordship.
upholding,
State judgment and order passed on 30th.
upholding,
There are 64. lordship.
upholding the aforesaid judgment
And order.
and
dated
order
30th.
dated 34/2011, passed in session case number 49 of 2009. In view of the aforesaid, Mr. Biswas submits that nothing survives to be adjudicated in the present appeal. In view of the aforesaid, the present appeal stands also closed, being infructuous.
Deeply obliged.
A copy of the judgment passed in criminal appeal 43/2012 is kept on record.
Deeply obliged. What about the
Yes, 23.
My lord, the,
But just please tell us the facts, how it was proceeded.
my lord,
Proceed.
it's my lord unfolded at page 17 by filing the FIR, my lord.
Page 17.
Page 17, my lord, of my lord, revision. Yes.
Yes.
The informed backstreet says, I am a humble and very poor lady. After the death of my husband, I along with my 3 children live hand to mouth. On last 9/9/2009 at about 1:30 AM, the below noted accused number 1, my lord, accused number 1 is the husband of the, my lord, present petition number 1, my lord. Called me to open my door, but I did not open my door as the intention of the accused was not good. And after the accused person returned back to his home, but once before leaving that he will take revenge of not opening the door. On 10/9/2009 at about 10 AM, the accused number 2 attacked me and wounded my left hand and forehead by stick as he was furious for disclosing the previous night's incident of the villagers. To see no alternative, I made complaint before the village people. As I called the village people at around 6 PM, the accused person illegally entered in my house and seriously beaten me and my 8 years daughter, Srimati Tutu Bormon, with stick. As a result of the assault, the accused person was ankle of left hand broken and received injury in my hand and on my forehead. On my halla, the village people came and the accused went from there, but the accused person threatened that they will face the consequences of the incident in future.
So 11/09/2009, it was filed.
It was filed, my lord. It was registered on 12, my lord, on the next day.
Incident is of 10/10. 10/9.
There are, my lord, 3 incidents, my lord, described. One is
9/9.
9/9.
2009. One is 10/9/2009 and other is
At, my lord, on the same date, one is at 10 AM and another is at 6 PM, my lord.
No. Okay.
My
Now
lord,
this is the FIR.
FIR, my lord.
11/9 FIR filed. Now where is the other FIR?
My lord, other FIR is not, my lord, annexed in this, my lord, case, my
Now
lord.
how do you take cognizance of that?
My lord, that, my lord, the IO has also stated, my lord, PW1 also stated, my lord, in their
Okay. Now after this, where is the trial judgment?
trial judgment, my lord, at page 21, my lord. Annexed 2, my lord. Here case number 491, my lord. And 9.
What are the evidences relied on?
My lord, evidence basically relied on, my lord, of 4 witnesses, my lord. PW1 was the, my lord, one Dupodi Bormon, my lord, the informant, injured informant. PW2 is one Rothin Bormon, the co-villagers. PW3 is Jugal Bormon, my lord. He's also, my lord, co-villager. And PW4, Pakhilal Bormon. And PW5 is, my lord, a medical officer, and PW6 the IO, my lord, in this case. At page, my lord, 25, para 13, my lord, the learned, my lord, Chief Judicial Magistrate, my lord, discuss about the exhibits, my lord. Page 20.
Now you lost FIR when?
My lord, on the same date, my FIR was, my lord, registered as Bongaigaon.
What was your allegation?
On the same incident, same allegation that they also beat me, my lord, and medical also is there, my lord. And
Now what is your argument in the aforesaid backdrop?
Why
She came to their house?
Okay.
As it was
Why
just-
we should exercise our revisional power in this case? Please help us.
my lord, at page 36, my lord, and except 4 is the death judgment, my lord.
Page
Page, my lord, 36, and except 4, my lord.
Page 36.
Except 4.
This is the judgment.
On which, my lord, the informant was acquitted, my lord.
Okay.
And GR case number 489/2009, my lord, if your lordship come to page 39, my lord, at para 13, my lord. My lord, the CGM as well as, my lord, the session judge also, my lord, discuss about the other case.
in their judgment in para 13, page 39, my lord. May I read, my lord?
Yes.
Admittedly, there is a cross case brought by the accused person against the wife and daughter of the informant.
So court also take note of that already you are convicted.
Yes, my lord.
Hmm.
In the cross case, the wife and daughter of the informant have been held guilty under section 341, 325, and 34 of the IPC. It has been submitted by the learned defense counsel that delay in filing the FIR is fatal to the prosecution. The occurrence in question took place on 10/9/2009 and FIR was lodged on 12/9/2009. There is no explanation for such delay in filing of FIR. I find force of the submission. I also find the evidence on record is not free from doubt. In the result, I find that the prosecution failed to prove its case against the accused person.
Now, what is your argument in that backdrop?
But a similar incident, my lord, as under my lord section 223, my lord, if any incident occurred, my lord, it should be a joint trial, my lord.
Suppose this joint trial is not there, then will the one conviction will go? Suppose it is not a joint trial. You have not raised that issue that it ought to have been a joint trial. Now, after when your matter was finally decided, by the time all earlier case was decided on merit, so only on the ground that this was not tried together, whole judgment will fall.
There are opportunities that they may file petition for.
That is one. That is one. Then
My submission is that the point taken in this case, my delay of FIR, my lord, that was, my lord, rejected in my case. And that in another case, that was, my lord, on that basis, they.
so can that benefit be granted at this stage? That is the second thing. Third thing is that the court recorded that it was on incident was 10th. In the FIR, it continued to 10th. And in this case, FIR is lodged on 11 at the night 6 and in the morning. In your case, you have lodged after lodging of the FIR on 12. But that is the findings.
My FIR was, my lord, registered as 361/09 on dated 12/9/2009 and GR case number, my lord, 489. And their case, my lord, in this case, it is the Bongaigaon PS case number 363. And the GR case number also.
No, that is fine. But when she filed it, delay will come not on the date of registration. Delay will come on which date it was filed.
My case was also filed on 11, my lord, that FIR is also available.
What are these judgments you are relying on? What is the conviction?
Conviction is for, my lord, 6 months, my lord. It was modified from 1 year to 6 months, my lord. And, my lord, the second, my lord, the FIR, my lord, indicated that there is a 3 dates, time of incident, my lord. But in the, my lord, deposition, if your lordship, my lord, you may read, my lord, PW1, my lord. Usurio.
Did you brought this contradiction during cross?
That is in
during cross, did you brought in? Because we'll have to remind ourselves that we are in a revisional jurisdiction, not an appellate jurisdiction.
PW1, my lord, in her deposition, my lord, stated that Gosoria Moy, Asami দুজনক চিনি পাও 1 বছৰ হল ঘটনা 4 বজাত ঘটনা আজি ৰাতি 1:30 বজাত ৰামেশ্বৰে মোক মাতে মই দরজা খুলি দিয়া নাই মোক কয় যে প্ৰতিশোধ লব পিছদিনা 4 বজাত my lord, the timing is also, my lord, different, my lord, totally. Earlier was 10:30 and 6, my lord. Here, my lord, পিছদিনা 4 বজাত আবেলি পাকঘৰত থকাত মোৰ আসামী দুজনে মোৰ ঘৰত আহি মোক মাৰধৰ কৰি বাও হাত ভাঙে. It is also not.
Now, what is the medical evidence?
Medical evidence is that, my lord, there is a
broken
fracture, my lord. But, my lord, who, my lord, assaulted, that was not, my lord, stated in anywhere, my lord. Even the trial judge and as well as the, my lord, appellate judge did not come to any conclusion that who assaulted, my lord. And that, my lord, assault weapon, my lord, that lathi was not, my lord, seized, my lord. In that respect, I have, my lord, one judgment of our High Court, my lord, Ipasaru, my lord. And even, my lord, the other evidence, my lord, they are the, my lord, improvement, my lord.
And we have also put, my lord, those, my lord, statement to the IO also, my lord. Which statement was, my lord, relied by the, my lord, learned trial court as well as, my lord, appellate court.
What is the sentence provided? No, no, actual under section 323,
341.
341.
No, 341 it was.
You are convicted under which
325.
Huh?
325.
What is the punishment in 325?
Seven years, my lord.
Which may extend to 7 years.
And
And shall also be liable to fine.
and
Then both will come. Not or.
and it was converted to 323. Not to,
No.
325, my lord, the.
only
sentence-
originally it was convicted under
Under section
325 and 341, my lord.
341.
341. Really.
Evicted.
Come prepared. Some other day. Difficult to give you the benefit of offender probation also.
It was discussed also in lower
My
court.
lord, in 313, no question or
313 we may incriminating material, which are incriminating materials are given.
But my lord, my defense was not, no question was put that anything to say, my lord.
There is some judgment, recent judgment by my Lord
Earlier
Justice
judge, my lord,
Bobde.
Reena Hazarika is there, my lord.
Rina Hazarika. My Lord Justice Bobde.
Yes.
What was that?
That, my lord, it's not only a formalities, my lord.
No, that is not an formality. That is
It's
fine. Incriminating material should be put to you. That has been put. Only thing is not put that do you want to lead, what you want to explain.
Yes.
So anything on that part. Anything on that part. See, two aspects. One is you must know what are the incriminating materials. Even if you are not given, and so only thing remains is whether incriminating materials are put to you. That so and so said so and so. If that part is over, now what remains is that whether you want to say something or you want to lead
last
evidence.
question.
If that part is then not there, whether entire judgment will fall. That is, you will have to address. Second part is that others, so if
On the
see,
evidences.
325 revisional jurisdiction, 325. And then fundamental thing is that what is the victim says and whether it is corroborated by the medical evidence. And contradiction here and there, 4 p.m., 6 p.m. may not be material contradiction until and unless there is contradiction as regards occurrence, place of occurrence and the attack. If this is consistent and it is corroborated by a medical evidence, then it will be difficult to interfere. So this part, if you can say that no, these are material contradiction which creates a doubt whether it is a fall, it is an attack, and this person has attacked. So you'll have to have a satisfy this court that there is a perversity. This evidence is required. However, this has been ignored. This is one. Second part, if you fail on that part, then next question will come whether the 313 part will be fatal to the conviction. Third part is your whole argument is that on the similar circumstances, when it was held by the one trial court as to be a fatal, similar will be applicable in this case. So one person has been acquitted on that same ground, other person ought not to have. Okay. And fourth, if you fail in everything, then fourth is
360.
that is probation and offender and section 4 and 5 and 360. 360. Or is there is no scope for conversion to fine? No scope. Take a chance. These are the points I think. If you can satisfy on evidence that there is a perversity, perversity wrongly appreciated, material evidence is ignored, material evidence is not taken note of, or unnecessary witnesses has been relied on, irrelevant witness evidence has been relied on, that is one part. Will not go any further than if you can satisfy. If that point is gone, second is 313. And if it is, if that is also gone, then limitation, I have a doubt on myself. You try it. The prayer of Mr. Sarkar, Learned Council, please this matter for hearing. This is a matter of 2012, no? Right. December 5, 6, 7, 6th of December. Come prepared. Okay, that's all.
Right.
We'll complete the other pending also, all this dictation and all.